One. It starts.
Hello and welcome everyone. My name is Parvasha. I am the Executive Officer of IACC West India Council. On behalf of IACC, it is my absolute pleasure to welcome you all to the second session of IACC Thursday Insights. Our initiative focused on delivering impactful ideas and meaningful insights. Today's session is on Workplace India 2026, Labor Codes and the Global Employer Perspective, where we will explore the evolving labor law landscapes in India and its implications for businesses from global standpoint. Before we begin, I would like to introduce our leadership team driving this initiative. Firstly, we have our president, Mr. Raghavendra Pongshe, a second generation entrepreneur and a distinguished intellectual property advisor. Mr. Pongshe is the managing partner of Bhate and Pongshe, which has a legacy dated back from 1965. His firm manages 15,000 IP assets globally. Beyond IPR, he is trusted advisor to family businesses and an active mentor within the Startup India ecosystem. Along with him, we have our Vice President, Mr. Manoj Balwani, a certified AI journalist and alumni of the IIM Ahmedabad. Mr. Manoj Balwani is the four-time entrepreneur and a seasoned management consultant. He also serves as a startup evaluator and mentor for premium institutions such as IIT Bombay and ISB Hyderabad. It is now my distinct honor to introduce our keynote speakers of the evening. Advocate Puneet Gupta, head of the legal at the H.L. Gupta and Co. Ludhiana. It is the third generation, he's the third generation expert in the industrial and the labor law. He has been actively involved in the drafting of the India's four labor codes, and with that, his contributions have been recognized by the Lok Sabha Parliamentary Standing Committee. A core member of CII Punjab, his policy advocacy has led to several significant amendments in the Punjab's labor law. Mr. Gupta brings a very valuable insights for today's discussion. We also have Mr. Dhruv Anand, a seasoned HR leader with over 22 years of experience in leadership, human resource, and organizational development. He brings deep expertise in driving strategic HR initiatives, talented management, and HR transformation. It is our great pleasure to have him here as our speaker today. We are also pleased to have our session moderator, Mr. Prateek Vaidya, IACC National Executive Council member and the seasoned business leader and a global entrepreneur, currently serving as the chairman and managing director across multiple ventures in the US, UK, and Canada. He brings over 2 decades of leadership experience. As the driving force behind Karma Global Consulting Solutions Private Limited, he has played a key role in expanding its global footprints. Now, without any further ado, I would like to invite our president, Mr. Raghavendra Pongshe, to deliver the opening remarks.
Thank you, Parva. Namaskar and good evening, ladies and gentlemen. On behalf of the Indo-American Chamber of Commerce, it gives me great pleasure to welcome you all to the second edition of IACC Thursday Insights. IACC has long been a catalyst in strengthening Indo-US business relations, while creating meaningful platforms for dialogue, collaboration, and knowledge exchange across industry and sectors. With this vision, we introduced Thursday Insights, a thoughtfully curated fortnightly webinar series designed to bring together industry experts and professionals to share impactful ideas and practical insights on topics that matter. Through this initiative, we aim to drive conversations that inspire action, turning ideas into impact through meaningful insights. Today's session focuses on a highly relevant topic: Workplace India 2026, Labor Codes and the Global Employer Perspective. As India moves towards a new labor law regime, it is crucial for organizations to understand its implications, not just locally, but from a global employer standpoint. This session will offer valuable perspectives to help navigate through this transition effectively. A warm welcome to our esteemed speakers, Advocate Puneet Gupta and Mr. Anand Dhruv. Mr. Pratik Vaidya, our moderator for this session, and all our participants. Thank you for taking the time to be a part of this session. Your presence truly enriches this platform. I am sure that today's session shall deliver meaningful takeaways and actionable insights. Thank you once again, and wishing you a very engaging and insightful session ahead. I now request Mr. Pratik Vaidya to take this session ahead. Over to you, Pratik. Thank you.
Thank you, Raghavendra, and it's indeed a pleasure. While I'm wearing three hats today. So first hat is, of course, Managing Director of Karma, and that's how. Thank you very much for introducing me, Parva. But second most important hat is that being a part of IACC in more than 3 years, and third hat is that I'm also a moderator for today's session, and I'm sure that we'll have a good interactive session. And most important thing is that we have more than 200 people joining here, and it has to be very informative and interactive, enough so that people have answers to all their queries, especially after 21st November. So before I invite my panelists in, and I want to just set the tone for this discussion very clearly. Can I have that presentation which is there? If at all, my team can share that. There has been far too much noise around the labor codes and far too little precision, which I would say. We have many WhatsApp forwards, half-read notifications, oversimplified webinars, and very confident conclusions. But when employer actually sit down with payroll, finance, HR, legal, and business teams, the real questions begin. So my own view is that the labor codes are now no longer just a reform story. They are live business reality. The revised definition is being treated as effective from 21st November 25. Can you just go to the next slide, please? So ministry's own clarifications are also indicating that gratuity from the date onward is to be viewed through the revised wage framework. Is it really true, not true? These are the four, brackets of codes which are there. All 29 are subsumed, and it's put it in these four codes. Whether it's 29 subsume or 28 subsume, I'll let you know in next thing. But what I wanted to tell you is that ministry's own clarifications are also indicating that gratuity from the date onward is to be viewed through a revised wage framework. And ESRC also has to be looked with the code wage definition. There may be so many notifications come from ESIC and then they retract it back saying, oh, now it is not under ES Act, now it should be under code on social security. So they are retracting back this. There's a whole so much of confusion there. But that doesn't mean that everything is neat and settled, right? One of the biggest mistakes I would say I see today, be it people, HR, and everyone are speaking in binaries. Either they say everything has changed overnight from 21st November 25, or they say nothing is clear, so let us wait. And I would say that both positions are very lazy. The real situation is more layered. Can you just go to the next slide? Next slide also, this is future. The real situation is more layered, I would say. Central rules, if you go to see, has been sought out and brought out from 21st November 25, which everyone knows about. But the practical difficulty remains around the state rules, appropriate government, operational readiness, your payroll system logic, if you go to see, then cost impact, and how regulators and court will interpret some of these issues in a live situation. And that's very, very important. And that's where we stand today. It's not yet fully enforced. At the state level, implementation still to be done. I would just like to take, say, PF and pension. Just can you make your next slide, please? PF and pension, when we talk about, the most misunderstood areas. The market has been speaking that the position is black and white. One act, which is item number 3, when you talk about the notification, the item number 3, which was of Employees Provident Fund and Muslim Provision Act, is not subsumed, which means PF Act still remains the way it is. and rest all the acts are now part of various codes. That's where the whole thing is. So this is very important for everyone to note about this. And also, there has been a phase in technical transaction. So, and this transition has to be precise, where employees need careful interpretation rather than just slogans that act as in place and everything. The next slide, just last slide, just wanted to check and let you know. If you see the state of the draft rules under labor codes, few states, I mean, of course, all the states, they have just either had a draft earlier and then they have revised it again. Even central rules, they came on 30th of December, and now they asked the time up to 15th February for a lot of organizations to actually put. Puneet has been a very, very good front runner on actually suggesting a lot of things for labor codes, what changes has to happen and everything, and all those, especially the rules framed therein. So, but again, it is not yet finalized. Nothing is there, right? So my perspective is very simple. There's not a time to panic. At the same time, there's no time to be complacent about it. There's time for disciplined interpretation, practical implementation, and honest acknowledgement where the gray areas still remain. And that's exactly what we're going to do today with the esteemed panel. Just last slide, I guess. I think I've finished my slide. So last slide, please. So you need to ensure that whatever your queries are, we are able to help you today. But you can also mail to wic@iaccindia.com just in case some of your queries are not answered. So we will try to bring that. So with that, let me bring into our esteemed panelists. While Parwa has already given, can you exit this? Can you exit the? And let's have everyone's face here. So can you exit the presentation, please? Stop the presentation. Thank you very much. So while I can see now everyone. Okay. While Parwa has already introduced Puneet and Anand, I know them very well. Puneet, I know it's the last 5 years we've been working on labor codes itself, and he's been very instrumental. He brings the legal and interpretation lens to the discussion, which is extremely important because labor code debate today is not suffering from lack of opinion, but suffering from lack of legal precision. And Anand, yes, he is part of the organization, he's the HR head, but at the same time, he also is a part of a very big association, Human Resource Infotech Association, and a lot of employers are also part of it. And he brings the implementation perspective, which in place where the real battle lies. Because the law may be notified in Delhi, but it ultimately has to work through the HR teams, payroll engines, and everything, right? So that's where it is. So let me start with the legal spine first with Puneet. So and move to
Please shoot, yeah.
Yeah, employer readiness. So let's go with the legal clarity with Puneet. So Puneet, the question to you is the most misunderstood area. Why I was just talking about a PF and pension. What is the cleanest position today, and what has actually shifted under the Social Security framework for our viewers and listeners to know? What continues through schemes and savings, and where employers are overstating the position? I hope you got the question.
Yeah. So I won't be fair if I say that Provident Fund Act has not subsumed or has subsumed. I must clarify on that part. On 21st of November, when the government has come up with the implementation notifications, it omitted certain point that relates to EPFO, as Mr. Pratik has rightly told, about an item number 3 relating to the EPF Act. But that has been set right by bringing a corrigendum on 19th of December 2025, whereby the central government has actually repealed the EPF Act. And now the EPF Act is no more in the books. It is a repealed act. However, the schemes framed around EPF Act, like the 3 schemes of the EPF scheme, EDLI, and the EPF schemes, they still continue, are being saved for 1 year. So all the compliances for the EPF Act has to be made under the new codes, but using the old schemes, all the 3 schemes, but using the wage definition, which is under the new labor codes, which has gone a drastic change under the new 4 codes. Yes. I hope I am able to answer your query, Mr. Pratik.
So then your point is that market is trying to force a black and white answer where the real position more layered. There have been aspects where PF, ESI, everything is not, active as it because the rules and schemes are not yet framed. So
Yeah.
companies have to still be going with the earlier act or earlier provisions. For example, in PF, the Supreme Court judgment and earlier provisions which were there, which define basic DA and retainer allowance, would be continuing with that unless the rules have specified and implemented, then only the new rules will come, right?
No, it won't be like that. Since the definition has been notified under the new four codes, now few new four codes has been implemented, and the wage definition doesn't require any rule to be notified. So you have to say obey to the new wage definition. And as per the wage definition, if anything which is come into the inclusion part, you have to contribute ESI and PF on that. Let me take an example for it. Earlier, house rent allowance attract ESI contributions.
Correct. Sorry, Puneet, you frozen. Sorry, I think.
Teams invitation.
Okay, let Puneet come back. Meanwhile, then let me ask the readiness now. Since Puneet has clarified on the PF front and the ESIC, I would like to know from Dhruv, your once Puneet comes back, I'll go back to him. But let me just help with you, Anand, that from an employer perspective and employer readiness perspective and standpoint, what are the single biggest mistake companies are making right now? Waiting for complete clarity still, or making payroll and policy decisions too casually?
In fact, to be honest with you, still we are somebody who are taking these things very lightly. What I feel is still we have that casual approach. Pratik, it's very important for each one of us to understand that from a compliance point of view, we miss the bus. While the compliance clearly mentioned, I'll give a simple example. Many cases, we take 45 working days or 45 days to settle somebody's PF or somebody's gratuity, etc., etc. Where in the new labor code, once we have this clarity, which we are definitely getting into a better discussion and detailed discussion, if we're able to close it within a day or 2 days, that's what ideal scenario has to be. But the challenge is, Pratik, the moment we give an option, and the difficult task is, we always look for options. Since it's a compliance part and we have to ensure that we follow the protocol, if it's a mandate for each one of us to do it, why to wait? Personally, I'm still exploring options that how further we can delay the implementation of these wages, of these compliances. And this is where, Pratik, I think we all miss the bus. Somewhere somewhere we are not mentally ready, and then that's how it's all about your perception. If we are supposed to do it, we are supposed to do it. Why are we saying we were supposed to do it? We were supposed to do it, and today we are not doing it. So definitely from this session and from this learnings, we have to ensure that if this is supposed to be done in 2 days, it is supposed to be done in 2 days. And from a HR point of view, let's prepare our team members, let's prepare our organization, because we are that important link between the employer and the employee. We have to ensure that we are ready with this implementation. And once given a go ahead, once we have that clarity, and once we know that this is what I am supposed to follow, religiously follow that and ensure that we meet the compliance, because many of us have missed the bus and we still continue to miss the bus, and the kind of perception which we all carry, Pratik, we still will continue to miss the bus. Hence,
I mean that there's no other choice because you're not missing the bus; you are going under the bus actually. So, Puneet, thank you to have us back because you would clarifying on the PF and you clarifying on this. So, what Anand is saying that they are still trying to see is there any option. So, be very clear with this whether they any of the employer do they option that or they have to go back from 21st November 2025 and say very clearly there's no other option, but you need to implement it. And
Yes,
what
you
they
have to actually implement. Yes, it has to be implemented. And from that point of view, I think he might be answering on that of a full and final settlement, something like that, over 2 days.
Yes, I did mention about that.
So I have some insight onto it. Say if an employee has filed a resignation, it is not actually that you have to settle it within the 2 days. You have the time to accept that resignation or to keep it on hold. Or you can ask the employee to say serve a notice period, which is being agreed into the appointment contracts. So it is not that within 2 days you have to settle everything. You have a time. The employers have the time there.
Correct. I mean, that is coming under section 17 of subsection 2, when we talk about this
Yes.
2-day working rule. And 2-day working rule is on exit, separation, and all that. And only it is up to wages, not about all other full and final settlement, all the aspects, It is purely on that. And for example, if you have absconded employees and everything, so that the 2-day rule may not apply there, because you need to find out how many days he was there and all those things, because you need to then follow the due process of the law, right?
Yeah.
So,
Yes.
this is where it is. And so okay, so just a follow-up question, the 2-day of which Anand was talking about, how do the employees separate wages from rest of the full and final basket, like leave encashment is there, gratuity is there, bonus is there, notice pay is there, recoveries are there, which is very, very important, which I say happen. So do they have to say this 2-day basket, a 2-day working rule is only for the wages part, and rest of the things is the other baskets is still the way it is going on, and they can continue with that?
Is this question for me?
Yeah, I was just asking this
Okay,
question for
okay,
you.
okay. So you need to refer to the various provisions of under all the 4 codes. For the wages you have rightly mentioned of section 17. It only relates to wages that has to be paid within the 2 working days. Now for the leave encashment, we have to refer to OSH code. Section 32 is there, subsection 8, if I am not wrong. It says that the leave encashment has also to be paid within 2 days from the date of separation from the company. Now, rest for the bonus and gratuity, there is a different timeline. Gratuity speaks of 30 days time. The employer has a 30 days timeline to pay that off. And for the bonus, actually, it has to be paid after the closure of the accounting year and have to wait for another 8 months. So you have that longer period of leverage to pay the bonus amount. So this is under the technical parts of that under the 4 labor codes. It is not only the wages that has to be paid within the 2 days.
Well, great. Thank you very much. So, moving back to Anand. In fact, so if you are heading, then if you have to say advising to the CFO or the director, what are the top 3 things they should have already reviewed by now on wage structure, gratuity provisioning, and maybe ESA testing? Have they done that? And in your in your another hat, where you are actually part of many associations, how the employers have done this over a period of time from 21st November 25 till maybe 31st March, have they done the provisioning? I just want to know from you.
So typically what happens is, a part of AOP, annual operations plan, which most of the organizations follow the protocol, between January to March, they have their provisions for the coming financial year as a part of their budgeting. Typically, a budgeting is a yearly activity which every organization does. So what I would suggest in current scheme of things, what we are discussing into, please have that provision in advance so that we are able to achieve and attain what we are supposed to do as a part of our team. So obviously, as a part of our budgeting, normally between December, January till April, March, we have our budgeting activity. Understanding the new protocol, Pratik, definitely my suggestion as a HR team, as a finance head to the organization would be, get this data ready in advance. While this is a yearly activity, typically, again, what we do is a typical mindset. We wait for the last day. If the submission is on 1st of April, we will run till 31st of March. That's the reason, from a provisioning, from a budgeting, and from a finance readiness point of view, definitely we have to ensure that from a AOP, from an annual operation plan, from a budgeting point of view, we are doing that rightly on the right time. So yes, from a finance head's lens point of view, we should be able to keep the data ready by 31st December, so that for the next coming year, calendar year, we have that 3 months to be able to play around from a financial year readiness point of view, because that 90 days period helps you to plan your budget well and execute the provisions which you have done from a compliance point of view. That is something which I think my finance team, and when I say finance team, HR and finance, while are 2 separate functions, but they are working together. Many organizations have the CFO working as a CHRO. I know many of my counterparts who are CHROs and CFOs of the same organization. So yes,
Got it.
it has to be in sync, and you have to do this in advance so that you are budgeting it in the right way, so that such kind of provisions which are there from a compliance point of view are being implemented right time.
So most of the organizations. So let me come to a restructuring issue actually. So if the exclusions cross 50%, the challenge is no longer academic, so that is where it is. So how
Right.
the mature employers, they think about the cars, perks, then you have variable pay, quarterly incentives, and other high allowance structures without creating this payroll chaos, because in the new wage definition, you have the base core wages, which is basic DA and retaining allowance, and then you have a bunch of exclusions from A to I, but which is not part of the normal HR jargon which you normally have, right? You have a lot of other allowances, things around it. So how is it being played, and whether these allowances are now moved in a way that they come into exclusion? Are the companies framing some policies around it so they can come into the exclusion bracket, something around that? Or they're just deferring payments like quarterly payments and incentive? I mean, just some perspective you can say, Anand.
Everybody is figuring out, Pratik, the right way of doing stuff. Personally, if you ask me, I have 4 organizations as a part of my journey. We are still figuring out that how we will be able to achieve what we want to achieve. But of course, since that compliance has come into picture, we have to ensure that whatever we have promised, whatever we have agreed from a compliance point of view, we have to follow that. So still we are figuring out that how we can choose the best option of the current availability from the overall benefits point of view, because from an employee benefits point of view, the laundry list is very big, Pratik. And that's why we all are struggling to come to a conclusion that once we have a better clarity, we as a team, when I have Puneet and when I have Pratik as a part of my panel, how we can better things, and basis on the insights, we should be able to choose and pick the best one.
Well, thank you very much, Hans. But then let me just talk to Puneet. And people are still figuring out, and many companies, Anand is also maybe one of the company which they are there. In fact, so let me just combine and repeat this question again.
Yeah.
That once the exclusion cross 50%, how should the employers think about company lease car, high value perks? Then you have, say, something remuneration in kind, quarterly incentive, or I talk about quarterly incentive or commissions, which is there, and some of the variable incentives. What really comes back into wages and what on periodic should be tested? I hope you got that question, Puneet. So
Yeah.
you can throw light on that. Yeah.
So if you go by the definition of wages, it starts with the words that all remuneration which is capable of being expressed in terms of money, a salary, allowances, or otherwise. The term otherwise is a very wide term which has been used by the legislature into that. It may encompass also the wages in kind into it. Now, if you see to the exclusion part, under the second exclusion, it says a value of house accommodation or the amenities or something like that of a wages in kind can be excluded from it when a special or a general order has been issued by the appropriate government. Now, there is no order. I hope there will not be any order by the government on that also. So they will not become an exclusion under the second part of the exclusion category. Now, when we jump to the explanation part, which says of a wages in kind, and it says that there is a capping of 15% of the amount will be treated as a wages in kind. So there can be two views. First view will be that when a wages in kind, the perquisites are all wages in kind by the employer. If it has been agreed by the employer through a service agreement or in a CTC by an employee, then definitely it can become a part of the wages. Yes, that can inflate the wage structure. And second view is that if it has not been agreed by the employer in a CTC, then it can be capped only up to the 15%. And for the statutory calculation, we have only to consider that part. So there are two views. Now we have to see how the government has come up with a clarification on it, or maybe it may be tested on the floor of the court.
So then is the labor cost impact, which is there, is it underestimated today? Because many boards still think, that like how Anand was also telling that it's just like a compliance cleanup for that matter. And whereas the more practical concern, maybe say PF or gratuity or overtime logic, which they do. For example, ESIC, I would like to talk about, since earlier ESIC was on the gross wages minus say washing allowance, and the ceiling is 21,000. Whereas now with the new definition as per wage code or code of social security or wages, which is there, Now, ESIC would be more like a basic DA retaining allowance, right? That's where it is. Which means if now my gross or total remuneration is around 42,000 or say 41,000 to be precise, my base core wage is around 21,500. No, 42,000. Yeah. So, yeah, 2,500, for example. So I'll be still covered under ESIC, right? So there's a bracket between 21,000 to 42,000. They all will be covered under ESIC. Is that the right position to make because the definition itself has changed?
Yes, you can say that only if there is a structure in that shape. It is not like that if you have a 42,000 as a total gross salary and by triggering the first proviso of the wage definition that the 21,000 has to be considered a basic. No, it is not the right position. If your structure is in a shape that there is a basic of a 20,000 or say 21,000, the rest are the allowances, then yes, you are right. ESI, you will become a member of ESIC and has to contribute.
Correct. Let's take it very simple. Like for example, the base understanding the allowances are 20,000, and the basic DA retaining allowance is also 20,000, which is a 40,000 as a gross wages or total remuneration, which is said, gross wages is nothing but total remuneration, and then you have other allowances or whatever the employer cost and all. So which means currently, this 20,000 as the base wages, the ESIC would be applicable, which
Yes.
otherwise it was not, right? Because it was more than 21,000. Am I correct?
In my view, it is applicable. ESI is applicable on such an employee.
Correct.
And that compliance was also required to be made from 21st November onwards. I must clarify here on that part.
Correct.
Even if there is some correspondences or notices issued by the ESI, which has later been withdrawn by them. But to my mind and in my view, ESI and the PF stands implemented on the new wage definition from 21st of November.
And that's very important that if the organizations, Anand, you talked about, you're just still catching up or just trying to figure out, you already are non-compliant under the PF and ESSE Act from 21st November 2025, because you're supposed to implement those and things around it, including restructuring and how the salary. When the rules will be notified, and unfortunately, if you could see, normally in labor laws, and because we are labor law experts and everything, the penalties are featured in the rules generally in the acts and all. Very few, seldom acts have their penalties in acts. However, the labor codes have all the penalties mentioned in the act itself, the labor code itself. So, generally the implementation and penalties and all are like a part of the rules, but this is not there. Which means if you're flouting, and many of the organizations still figuring it out, and the catching up game is still there, you already are non-compliant, which I can say very clearly, right?
Yeah.
Advocate Puneet.
Yeah, I agree with you.
So let's go back to Anand. There are like BPOs and KPOs and white collar service employers, especially with hybrid and work from models. So, there is a act there's a code called as OSH code, actually, which changes in practice. What generally matters is what is getting exaggerated. So what do you think that how this work from home models, which were earlier not been covered, now with the occupation safety and health, that is OSH code, it brings down the change practice. Have the organizations changed any policy towards it, or they've just continued the policy what they were trying to do, compliance from the code era period? I would want to know from Anand first, and then maybe the legal position from Puneet here. Yeah, Anand.
So when we talk about the IT part, typically from the KPO, BPO, and IT organizations' point of view, yes, many organizations are still following the typical work from home model. But yes, with this new code, with this clarity, if that's a mandate which we have to follow, obviously a lot of restructuring needs to be happened. With the manufacturing kind of setup, with the mandate setup where somebody has to mandatorily have that field, presence, has to be physically there, present in the organization, in the office, that will be definitely a challenge, because with many organizations who are providing work from home options, this entire compliance lens is going to change the complete dynamics of the working mechanism. With the manufacturing setup and the kind of setups where typically people have been mandatorily asked to have that 5 days a week, 6 days a week kind of working lengths. Yes, this compliance is going to change a lot of dynamics in the day-to-day working mechanism. But yes, from the work from home and from a security point of view, yes, this compliance is going to ensure that all these employees are covered with a complete a positive approach. And then, of course, with Advocate Puneet adding to it, we would love to have that insight so that we know how we can be more productive and more aware of such kind of compliances which we have supposed to get into.
So yeah, so just to add here, Advocate Puneet, I would also like to ask here on behalf
Yeah.
of our user that for say multi-state employers,
Mhm.
how much comfort should companies really take on all the FAQs and informal clarification which is coming, given that state rules and appropriate government issues are still matter heavily and they are not yet implemented. So how they should be doing it right now, and how they should be framing up and implementing things around it.
See, you have to go by the state-specific rules. We have to see all those rules of the state also. Most of the states are framing the rules. In Punjab, we have already have the 4 rules for the public opinion, and we have filed objections to and suggestions to it. And most of the rules which I have been seeing that it is being a copy paste from the central part. So if the governments are insisting to only have a same rules which the central government is having, then there won't be any issue. But if there is any deviation, then yes, every state rule has to be verified and checked before implementing or making any policy around it.
Great.
So,
So if you're advising a board today, for example,
yeah.
And what are the single legal risk under the labor codes that is most likely to become expensive because employers are underestimating it? And I think Anand also clarified it. They're still underestimating figuring it out. What is the single legal risk under the labor code that is most likely to become a big expensive for employers?
The answer is already aware for everybody knows that this is the wage definition that has come. The cost impact is going to hit very harshly to the companies now. We have been say restructuring the salaries for many of the companies and seen that the bill has gone very high. Yes.
So then if you have to give like an action list, what are the action, like a 30-day like an action list, what they need to do, doing all CHOs, CHROs, CEOs, CFOs, what is the action list they need to do from today onwards? Let alone if they should have been done the action from 21st November 2025, but what should be doing it? Because there was a lot of news also around this that now it will be implemented from 1st April onwards, and we'll have to see the retrospective manner and all. But there is just a chatter which goes in the news, and half of the news is all, what the interpretation is all about. So, what would be the action list you'll give?
Before that, I must apprise the house here that the implementation of the rules is not dependent on the implementation of the code actually. Or I should say otherwise, the implementation of the code is not dependent upon the rules. If you see, there is a provision under the General Clauses Act, it's Section 6, and read with Section 24 of the General Clauses Act. It says whatever been made under the old rules will continue until it is being superseded or appealed by the new law. So all the rules which are framed under the old laws will be continuing and are continuing because they are not been repealed by the new notifications. So those are continuing. And the second part that you say about what is the 30-pointer list? What are you saying there?
No, I'm saying the 30-day. I'm saying the 30-day. What are the what you can say, labor code action list? I was talking about from here, like April 9 to say end of April or maybe 10th May. I mean, what are the 30-day list which the employers, the CHROs, CEOs, and CFOs, they should really see and do it if they have missed the bus? That's what Anand was saying. Yeah.
One and foremost, they must have a relook on the wage structure. This is going to cost them heavily.
Absolutely.
This is the only thing that I am saying. Rest is the regulatory compliances that you are already making under the Provident Fund law or the ESI laws. These are the two main laws where the monetary aspect is concerned. So rest is all the regulatory part. I think the main is to have a relook on the wage structure, yes. And also onto the appointment letters that you are issuing to the employees, whether they are comprehensive enough to cover all the issues or not. Because many of the establishments say is having a strength below 300. Now under the IR code, the standing orders are to made applicable only to the establishment having a strength above 300. So many say employment related things like a transfer or say retirement or something layoff or many provisions which are coming from the standing orders, which are not going to be implemented on an establishment having a strength below 300. So you now to have a comprehensive appointment letter issued to all the employees. So these are the two things that I believe that CHROs must be looking into it.
Great. Thank you so much. I think, you know what, we will take the questions. It's very important because this whole objective here was to get clarity. And I think before I want to get questions from the panel here, from a lot of participants who have put the question, I'll read out that. 2-3 pointers which I want to make very clear, and I'm repeating again. A is that while it was general that item number 3 PF was not there, but then we already have the notification place that PF is also repealed. That's very important. That means PF or ESIC, or for that matter, gratuity, if an employee leaves also during this period from say 21st November 2025, say till 9th April, if an employee leaving, the calculation has to be as per the new wage code. That's very clear on that. So that's the clarification which we had. The wage structuring, if people have not done yet, they need to ensure that they really do the wage structuring as per the new labor codes. So that's very important. We also have shared certain presentation on SEPS website, and people can do. And for all our IACC members, if you're not a member, then you should be a member, because what we're trying to give here via IACC is that if you're a member, then of course you'll get the checklist, actual checklist you need to follow as per labor codes. And if you're not a member, then please become a member, and then you can follow the checklist. Very important. So that's very important, and the checklist is curated by experts here. And I would want even Advocate and Puneet also to share, give the checklist, or I will share the checklist, and then he will be curated by him. It's very important that the compliance is implemented, no longer missing the bus, no longer just figuring out things. It's very clear. You're already late before the authorities jump, though they have been calling as the facilitators and not an Inspector Raj as such. But I'm telling you, the labor codes has a very severe penalty than the erstwhile acts. You don't want to be coming in the soup. So that is where it is. Now, gentlemen, let's go ahead and take some questions before I hand over it to Parva here. So let's see some chats. People are having some questions here. Anyone wants to ask questions, it's very, very clear. Please feel free to post your questions in QA box. I want to repeat once more time that this session is very important to note that the clarity, see, you must have attended a lot of webinars and seminars, but clarity which is brought here is very clear that the labor codes are active. Do not wait for rules to be implemented. You need to act immediately, as on yesterday. If the rules are implemented, then the authorities will start catching up with you and ensuring that you are compliant or not compliant. Better not to have embarrassment at all. So that is very important. One of the question was that which of the components are excluded while there is a range from A to I. If Puneet, if you can just tell what things are excluded, and if these nomenclature are not there in the payroll structure, what happens to those? These two questions are there. What are the items which are excluded? Number A. There is also item number C, which is PF employer contribution, which cannot be taken as a 50% test. So that is the clarification which people need, because if you see a 50% test is only for the contribution given from employer to employee, whereas the employer contribution PF doesn't come into that 50% test. So what are the exclusions people need to see? Number one question. Number two follow-up question is, which people are asking is, what is the rule of the 50% test and what have to be going back to wages? Yes.
So I will answer the second part first. We have to understand what that wage definition says. I can divide that wage definition into 3 parts. The main part would be the first part, which defines what is the wages. Wages means all remuneration, including allowances and salaries, and a component called otherwise. Otherwise is a very wide term. I've already spoken about it, which is being paid to an employee if the terms of employment is fulfilled and is paid in relation to his work done or the employment in the establishment. So if all these qualifications are there, if that is being satisfied, then that amount will become his wages. Now, legislature has very clearly mentioned that three parts will be wages. That is basic pay, dearness allowance, and retaining allowance. To my mind, these allowances are these three items are only illustrative. All other allowances which will not fall under the exclusion part will automatically become the inclusion part in the first part of the main definition. Let me take an example. Let's say you have a special allowance into your component list. It is not being parked in any of the exclusion list. Then that special allowance, which is not having any basis or any background, you don't have any policy around it, then that special allowance will automatically become the main part of the definition, that is inclusion. So when the inclusions and the exclusions, when you see exclusions exceeds the inclusions, or I can say when first proviso is triggered. First proviso will trigger when your total remuneration is taken and we say have 50% of it. If the exclusion exceeds that 50% mark, then first proviso will trigger and the deeming wages will come into play. You have to add back that into the inclusion definition and has to pay the statutory part of it. Now, you say what are all exclusions to the definition? The first query that you have raised. That is one is the statutory bonus. Now, we can go into detail what actually it means and what it actually does not. I'm just giving a little light onto it. When you pay a bonus on a monthly basis, that bonus can be taken into consideration as a first exclusion of this definition. But if it is being paid a lump sum on an annual basis, then to my mind, it should not be taken into consideration for that calculation of the wages. Now, the second part is the wages in kind when you say value of any house accommodation provided by the employer or such amenities being supplied by the employer. So all those components will be in the exclusion. Third will be the contribution paid by the employer to the PF and pension funds, including the interest thereon. And the fourth one will be the conveyance allowance or the traveling concession paid, or then comes the sum paid to the employed person towards the defraying the special expenses. Now, this is a very interesting thing. What actually components come under this defray special expenses? Some companies will say that we pay heat allowance, or we say hill allowance, or we say anything that allowance which is related to the employment. But we have to see whether it is being paid to defray a special expense. If the answer comes to be yes, then only it can fall under this part. Otherwise, it will become the inclusion part.
So there's a question related to this, like which components can be considered excluded this particular defray special expenses?
Yeah.
Like there are components such as professional development or club membership or books and periodicals. Can this be considered excluded for wage computation purpose as part of a defray special expenses?
See, for books and periodicals or the club membership, it is not related to the employment which he has to undertake, the expense that he has to undertake for that. If you can explain to the auditor or to the inspector cum facilitator that these are actually the defray special expenses and he is agreed to that, then you can be allowed to take that. Otherwise, it will not. It
So
depends
how do you ensure that the policy is made a way that it is acceptable to the authorities or inspectorate? Yeah.
Let me give you an example which actually falls under this category. Let's say you have a uniform. You are giving a uniform for a worker class category which he has to wear while, or even to the executive, which they have to wear and come to the company. Now that component of that amount can be taken as the defray special expenses. And also the washing allowance if a company pays to the employees or to all the employees, that can also be treated as a defray special expenses. So you have to treat each and every allowance separately. Now the next exclusion is related to the house rent allowance. That is very clear to everyone. Another is for the remuneration paid under any award or settlement or a court order. Then comes the overtime allowance. And last one is the commission. Last one, when I say it is from A to I, which we have to see into the first proviso. Otherwise, J and K is there. That is all the retirement benefits that has to be given to the employee. So these are the exhaustive list. The legislature is very wise in drafting this definition because they know that employer used to say circumvent the definition under all other allowances, which they have definitely not put into this definition now. You cannot park any other allowance which is not being listed into these exclusions. It will all become the inclusions now.
So which is like that means any of the allowances or fancy names, and if we have very innovative HR and innovative HR, fancy allowance and names which we have, there are certain things which is as per income tax as well. Those allowances which are taken would be coming exactly as part of core wages, right? And those which in other words, and it's very important for all the users to listeners to see, allowances which are not part of exclusion list are going to be part of core wages. Simple.
Yes.
Whatever name you call. Oh, that is very clear. So,
Uh,
so there is no other escaping out at all. Yeah, if at all those allowances which you feel no, this is just given to some employees and some not, and their reimbursement and all, you need to define a policy in a way which is convincing enough, as told by Advocate Puneet here, to the authorities. And if that is convinced, then you can be putting as a part of a different special expenses and get it in exclusion. However, overall total of the exclusions, it is 50% more than the total remuneration. Then balancing figure will go back to the core wages, and which on what the basis PF, ESI, gratuity, and bonus would be calculated. So that is very clear here. So I hope everyone heard it, and we are very clear. There's one more last question here before we just give it back to Parva here, that labor codes and Karnataka state rules have a very different overtime hours limit. So there's a more than 8 hours per day versus 10 hours per day. And I think they're referring to, I don't know, 10 hours and 8 hours, but I thought they may be referring to the extended hours. What can be considered more beneficial for employees in compliance from labor codes point of view? That's the question which has been asked. Or can keeping 9 hours a day working hours to be considered compliant for both statute requirements? That's the question which is there.
See, if I get the question right, if you see the OSH code as well as to the code on wages, they have defined the normal day of working. What will be constituting a normal day of working? There they have mentioned 8 hours a day. Previously, if you see the Factories Act, there was 9 hours a day which was allowed to an employee. After the 9 hours, then the overtime will trigger. But now they have say 8 hours a day will be considered as a normal working day, and the overtime will trigger post that 8 hours working. I hope I am able to answer the query to that.
Yeah, I think so. Yes. So, that means they are asking that what is the statute? And mind you, in fact, whoever is asked now, you have to also see the Karnataka state rules for labor code as well, because that's very important. While you may be mentioning the Karnataka shop and association rules, but you need to see. So now, if that happens, do you think that Karnataka shop and association rules or any of the state shop and association rules which governs this overtime and working hour limit, they would be also getting into change because of the change in the central legislature as far as OSH code is concerned or the working hours is concerned?
See, we have to check actually. If that establishment is a factory, then obviously the state shop act will not apply to that.
All right. There's one more question, and I think it's an interesting thing, which I'm sure that many of your people also have this question. It's about the leave encashment. That's very, very important. All the Shop and Association Act across states, there is no provision of leave encashment unless it is a separation. Okay, and you are supposed to carry forward the leave. So there are some stages 45 days, some 60 days up to you can carry forward the leave up to so many days and only carry forward PL, that is privilege leave.
Right.
The question is, as per OSH code, you can carry forward up to 30 days. And beyond that, so earlier in the Shop and Association Act, you whatever leave carry forward 30 days, 45 days, and all, beyond that, it used to lapse. You cannot carry forward, and you cannot do leave encashment as well because there is no provision. However, on the OSH code, can you give clarity that about 30 days, if the leaves are there as a balance, can it be encashed? Because that's a provision which is given. So what is the difference between both earlier act and the new OSH code, especially leave encashment is concerned?
So I would like to answer this query by referring to the Article 254 of the Constitution of India. It talks about a law of repugnancy. If there is a conflict between a state law and the central law, or the law made by the parliament, then the law made by the parliament will prevail over the state law. Now, there is a provision under the Occupational Safety Health Code. There is section 161, if I'm not wrong, which says that the provision OSH code will prevail over all other laws, which are for the timing are there. Let me refer to the exact section there if I'm not wrong. It's 120, sorry, not 161, it's section 120. effects of the law and agreement inconsistent with the code. At the outset, it says the provisions of the OSH code will prevail. But however, it has a proviso attached to it. It says when the provisions are beneficial to someone under the other laws or under the agreements or the contract of service, then the employee can continue to have the benefits under that law. So we have to check actually whether those provisions are beneficial to those provided under the OSH code or not. The
Got
answer
it.
lies here. Yeah.
So that this answers the question about Karnataka and labor codes, and so that means the labor codes will supersede the
Yes.
state rules. That's very clear. My other question was, and which the question is asked is, we'll go with two more questions and then we'll end this year. It's about under Section 32 of OSH code about the leave encashment, where I was talking about that earlier, the Shop Institution Act and whatever the acts are there, the leave encashment was not there at all. Where the OSH code, when it says that if the worker has worked more than 180 days and 1 day for every 20 days worked, then normally, which used to carry forward 30 days, and then beyond, if it is 30 days, the leave encashment has to be given by by the employer, and the leaves will not lapse. Is that correct here?
The answer again will I have to refer to section 120 of the OSH code, where the overriding provisions are given. So if the provisions are beneficial to the employee under the State Shops Act, then we can say yes, he can continue to have the benefit under that. If it says by carry forwarding the leave for the next, let's say up to a certain limit, or the limit which has not been prescribed under the State Shops Act, then you can say that these provisions are more beneficial to the employees, not to the worker. I'm saying employees, because section 32 applies only to the workers. Worker has been separately defined under the OSH code. You have to see whether he is a worker or an employee, or should I say worker or a non-worker.
Correct. Up to 18,000 wages. Am I correct?
Yeah, and performing supervisory duties. These are the two conditions that has to satisfy for a person to be outside the definition of a worker.
So worker wages up to 18,000, or it is supervisory of wages up to 18,000?
Yeah, supervisory and wages up to 18,000. Above 18,000.
And worker is no limit of his wages. Am I correct?
No. Let me come again. Worker is the person who is drawing the wages up to a certain level. Every person, no, let me explain again. Every person is going to be an employee, but every employee cannot be a worker.
Correct.
Right? So any person who is who is in a supervisory capacity and drawing wages above the 18,000 limit, he will not be a worker under this law.
Okay.
He will become a non-worker, or you can say he is fall under the wider category, that is employee.
So for this leave encashment perspective, which is applicable to worker, and he can encash that leave, if the worker is having wages of say 18,500, would it be applicable to him or no?
Yes, it will be applicable to him, because you have not suggested that he is doing supervisory capacity work or not.
Correct. So worker, irrespective of his salary, he remains worker, and he enjoys that particular provision, which is annual leave with wages, which accrues to the worker, and beyond the 30 days or whatever you put, he is entitled for leave encashment. Whereas supervisor above 18,000, they will not be entitled for that benefit, because we are not leave encashment. Only I'm talking about, guys, I'm just talking about leave encashment perspective, which is very, very important. So this is an area where state speculation, I mean, one side doesn't fit all kind of thing. So Anand, this is very critical for you and the Asia spokes around it and all. When you're framing the policies and seeing that the employees, and I'll tell you, for example, when talking about BPO or LPO, which I'm talking about, the software engineer, the software engineer, the tester, and all those guys come as a worker only.
Yes.
The supervisor, and they may be having salaries of 50,000, 70,000, 1 lakh, doesn't matter. The airline pilot is also a worker, unless, and that is established in many of the judgments also. Airline pilot having a 2 lakh salary, but he's still a worker, which means if they have to go for leave encashment, they are eligible for that. However, a kind of a housekeeping supervisor, which is having a salary of around 20,000, he would not be counted as a worker, and he will not get this enjoyment benefits of leave encashment. per second. That's what the clarity is all about. All right. I think the last question I'll take before I'm handing over to Parva here. So the question here is that is there any provision under the code that states that if a company has multiple offices across different states in India, the central rule shall apply instead of respect to state rules? Well, that was earlier in the Industry Dispute Act as such, and depends upon the industry. But I think I would want Puneet, your expert opinion on that. So I'm just repeating the question. Is there any provision under the code that states if a company has multiple offices across different states in India, the central rules shall apply instead of respect to state rules?
No, it is not like that. Even if you have a multiple offices in other states, it is only the appropriate government which will be governing all the things. You have to watch the rules. Now, rules framed by that appropriate government. Now, who will be your appropriate government? There are certain categories has been mentioned in all the appropriate government definitions, that these type of industry will be governed by the rules, or the central government will be the appropriate government for them. And for everything else, every establishment will have a state government as their appropriate government. Even establishment having a multiple office, still they have to obey to the state rules, not to the central rules. But if you're having a establishment office in let's say in a union territory, let's say in Chandigarh or in Delhi, then the central rules will prevail.
Absolutely right. In fact, and just to give more perspective to that, the mother of all the acts is the Industrial Dispute Act 1947, which came before all the acts, and there the appropriate government is very clearly defined. Either it is your oil, petrol, banks, public sector units, all will coming under central labor, and you need to follow that central also. There may be a situation where the central act would be applicable. However, minimum wages, the state act would be applicable. So there are nuances around that as well. If it's a private bank, though it is covered under central labor, but because it's a private bank, it is not a public sector unit undertaking. The state rules will apply, because the minimum wages definition is very different than in the industrial dispute. So the rules also of the labor codes will also define the appropriate government very soon. In fact, that is very important. So that's it. I think we've answered almost all the questions here, and I would want to give this back. I would say the dais and the virtual dais to give back to, or lectern, I would say, back to Parva. Parva, over to you. Thank you very much, first of all, to Anand and Puneet. It was a very wonderful interaction, whereas Anand gave the perspective of how the employers are still catching up game. But I think this is very clarifying that there's no catching up required. You need to do, otherwise you'll be under the bus. And thanks, Puneet, for all advices and all. Thank you very much. Over to you, Parva.
Thank you so much, Prateek sir. It was indeed an amazing session, great discussions. Now I would request our Vice President of IACC, Mr. Manoj Balwani, to propose the vote of thanks for the session. Thank you.
Thank you very much, Parva. Am I audible, everyone?
Yes, sir, you
Okay, great. So they say that time is the only currency that you can't earn back, right? And all of you have spent the last 60 minutes of your precious evening with us. Puneet and Anand, thank you very much for ensuring that our audience's investment of time has paid off. You didn't just decode the 2026 labor code for us. You've literally given us a roadmap for the modern Indian workplace. To Prateek, our moderator, thank you for the surgical precision in steering this dialogue. Now, behind every successful IACC initiative is a relentless engine. Today, that engine was fueled by Vishnu and Parva from our secretariat and steered by the leadership of Raghavendra. I'd also like to acknowledge my partner, my co-vice president in this journey, Tejinder Oberoi. He's unfortunately traveling today, but his presence is felt in the very DNA of this Thursday Insights platform. My final thanks goes to you all, our participants, because in a world full of digital noise, you chose to engage in this high class, high level masterclass with us. We are all very confident that you won't just be leaving this webinar empty-handed. You will actually take these insights back to your boardrooms. This was the second edition of the Indo-American Chamber's Thursday Insights initiative. We are just getting started. I'm Manoj Balwani signing off on behalf of the IACC. Let's go out there tomorrow and build better workplaces. Thank you.
Thank you all.
Thank you, everyone.
Thank
Thank you, everybody.
Thank you.
Bye-bye. Thank you.
Just to add, any other questions people have, I think they will be sharing with the WIC ID. So let them ask us, and then we'll answer them. Thank you very much.
Thank you.
Thank you.
Sir, can we close the session?
Yes.
Yes.
Okay, sir.